We have witnessed some strange battles in court which defy all logic, and yet they happened. From promises that turned into courtroom showdowns to victories that sound more like myths than legal rulings. These cases prove that the truth can be far stranger than fiction. Each bizarre lawsuit is a reminder of how unpredictable justice can be and how the smallest twist of fate can turn into a story for the ages. Welcome to part 2 of the bizarre lawsuits in the US history. Hello everyone, welcome to the bizarre world of mine. We study the entire world for our audience to know some of the weirdest cases all over the world. So guys, we are back with the bizarre lawsuits in the US history part 2. You're not new. If you are, press the subscribe button along with that cute little bell icon. Pack your bags. This is the video where we cover the weirdness from the Harry Potter ride to a woman suing herself to suing her girlfriend. Sounds crazy, right? It definitely is. Let's move ahead. Moving to our first case. Not taking everyone so far, here only it's nearby 2022. This case is about Pamela. Don't get excited. She's Pamela Morrison. Morrison, a 74-year-old Arizona woman, accompanied by her grandson, went on the Harry Potter and the Forbidden Journey ride at Universal Studios Hollywood in September 2022. And something crazy happened with her. What crazy could have been? What's crazy for you? Pause the video and just write in the comments. Okay, you're back, I guess. Morrison suffered a severe spinal injury after falling while exiting the ride. Can you believe it? The injury occurred when she was instructed to exit the ride due to her harness not securing properly. While stepping off a moving walkway onto stationary ground, Morrison slipped and fell, resulting in a crushed spine and significant physical harm that impacted her daily life. The belt was still moving and so my foot went on that belt, Morrison stated. And then my other foot went on to the stationary floor and it knocked me off my feet. Morrison stated this. The lawsuit claimed that the park failed to stop the moving walkway, which would have allowed Morrison to exit safely. Instead, the ride was kept moving to meet a high operational goal of 1,800 riders per hour. Morrison's attorney, Taylor Cruz, argued this prioritization of ride throughout over guest safety caused her injury. Who all can imagine the pain Morrison had gone through at that age? Obviously, the defense was Universal Studios. They had their homework done too. The defense attorney, Edward Ward, claimed that Morrison was distracted by her grandson and responsible for her own fall. As described in the documents, Morrison sought monetary compensation for various acts of negligence, including premise, liability, and negligent hiring and supervision. Everything was dependent on the jury. After a 3-day trial, a California federal jury deliberated for 4 hours and found that Universal Studios was liable for hazardous conditions that led to the injury. Morrison must have got a sigh of relief. The jury awarded Pamela Morrison $7.25 million in damages, including $250,000 for medical costs and $7 million for pain and suffering. Whoa, that's a lot of money, guys. Expert testimony highlighted the danger of exiting the ride's moving walkway and criticized the park's safety protocols. Overall, it was a significant negligence case highlighting theme park safety and operational decisions impacting guest welfare. And Morrison won. So here's the first case of our roller coaster lawsuits. Let me know in the comments, what would you do if you won this big amount? Okay, So that was the craziest Harry Potter thing you must have heard of or witnessed, if you could imagine yourself in that. Partners in the house, first of all, press that like button if you haven't yet, because this case is for the ones who aren't single. It doesn't mean that if you're single, you won't like or subscribe. I'm pretty sure there must be n number of partners who must be ghosting or being ghosted once in your life at least. I can't even figure out how many ghosts must be happening every day. But don't worry, ghost stories would no longer be boring after you listen to these cases. First, I'll take you to Singapore. Not really, but yes, you can imagine it always. Mr. K. Koshigan sued Miss Nora Tan for emotional trauma amounting to $3 million after she rejected his romantic advances and decided to end their relationship. I'm taking a pause here to imagine the happiness on all those faces who must be ghosted or rejected. Koshigan alleged the rejection caused him trauma, depression, and impacts to his business partnerships and personal well-being. Someone is making this a genuine problem. Thank you, God. He lodged 2 lawsuits, a high court claim of US $3 million for damages to his reputation and emotional suffering, and a smaller magistrate's claim for breach of an alleged agreement to work on their relationship. He actually did this, breach of an agreement to work on their relationship. Respect to you, mate. Poor Miss Tan, she must be shaken after seeing this. This is the person I loved. Definitely not. Miss Tan responded with a protection order, claiming harassment and reporting threatening messages from Mr. Koshigan. The action highlighted the importance of clear legal boundaries around emotional distress claims, particularly those stemming from failed romantic relationships and unrequited feelings. Hence, the court didn't take any decision as there was a protection order. As they said, legally actionable harm is much different than a heartbeat. I don't like this judge. Let's go on to another such case. No resting in these cases. Time for Canada peeps. Did you do your part as I'm doing mine? Pause the video. Go to that bell icon. It's waiting for you. People ghost when the purpose is over or they don't love you anymore. Agreed? If yes, then leave a comment sharing your ghost stories, as sharing is caring and it makes you stress-free when you share a problem. Okay, coming back to Canada. Lawrence Campbell sued his ex-girlfriend Crystal McKay after she ghosted him following her claim of a $5 million lotto 6x49 prize from a ticket Campbell bought. Poor Campbell. Maybe he would have planned so much with the money in his hand. Campbell and McKay had dated for over a year, living together and sharing family life. After Campbell lost his wallet, he allowed McKay to claim the winnings, trusting that she would hold them in trust for him. Shortly after, McKay blocked all communication and cut ties, leading Campbell to allege emotional distress, betrayal, and financial losses. Boy, too early to trust someone. I can't even imagine how he would have felt at that time. Getting ghosted is bearable, but getting ghosted and losing money too. It sounds like a sale offer of buy one and get one free along. The boy wasn't weak at all. He sought both a constructive trust over the winnings and damages for suffering caused by being ghosted and deprived of lottery proceeds. Same like the Singapore case, McKay responded with a protection order. The court and the law says emotional distress lawsuits require strong evidence showing intentional or negligent infliction of trauma, including medical or psychological documentation. Courts tend to be skeptical of emotional distress claims solely stemming from romantic rejection or ghosting absent financial fraud or other independent torture. Poor Campbell. He tried a lot to gain something over his loss, but that's where the reality creeps in. To conclude, these ghosted cases, protection orders and counterclaims emerged. with judges emphasizing personal boundaries and the need to differentiate heartbreak from legally actionable harm. Yet, the entire men's community must have had a mad respect for these two men. Let me know in the comments section, what would you do if you were in their place? Would you forgive the person or would you sue too? The section is all yours. I hope you're out of the traumatic ghost stories. Let's move on. Oops, my bad. Let's move ahead with the video, guys. So, our next bizarre case is about a robbery. A successful robbery, that too. My favorite line, pack your bags. This time we are going to the late 80s. First things first, if you haven't subscribed to the channel, do subscribe to it, and that bell icon is waiting for you. It's not like your partner, it waits. Let's go and see what happened back then in 1987. Daniel Canelaro, a convicted bank robber in California, sued the city and the bank he robbed for $2 million after a booby-trapped bundle of stolen cash exploded in his pants, causing severe burns. Like what? The banks, I must say, were smart way back then too. Poor Daniel, he claimed the bank should have known the booby trap, which is a disguised cash pack containing dye and tear gas, had devastating effects, and that he was in extreme pain as a result. Like bro, you were a crazy person back then. However, his lawsuit focused on the effects after the crime, not that the bank was negligent for allowing him to rob it. But then too, it takes some courage to sue someone after taking their thing and suing for what? For protecting your thing, which I'm going to rob. People used to be full of life in the 80s and the 90s. Look at us. We are living a monotonous life every day. There are other legally strange cases such as robbers suing for injuries sustained while fleeing from police or during attempted robberies. But courts overwhelmingly dismiss such cases as lacking merit. Another crazy man named Todd Kirkpatrick, a serial bank robber, after being shot by police while fleeing, sued the county for medical costs, alleging excessive force. Can you believe it? People are suing government servants for doing their job efficiently against you. Who is the person wrong in the story? Obviously, every person is the hero in their own story. His lawsuit was dismissed by a federal judge. Despite urban legends and internet memes, there is no credible, documented case of a robber successfully suing a bank for having poor or no security as the basis for the robbery itself. And there shouldn't be one too. Most legal actions over bank security are customers suing banks for losses incurred during robberies, not robbers trying to claim damages due to ease of crime or lack of prevention. These robbers had a crazy entitlement. They wanted to rob a bank without any consequences. How is this even possible, guys? This is reality and not a movie where the police arrive late. To conclude this bizarre case, these lawsuits are often cited as examples of baseless litigation and are routinely rejected in court. Let me know in the comments section, what would you have done if you were either of the two, the robber suing a bank or the judge making the judgment? Stay tuned, and we've got more in this video. So far, we have gone through a cycle of a crazy ride story to partners sued for ghosting tales to the iconic robbers who sued for getting injured while committing a crime. Things are going to get more bizarre as we are going to witness this crazy case. Come back a bit ahead from the 80s and the 90s. It's 2011, December in Utah, where a woman sued herself for her negligence. Let's dig deep. The accident occurred in December 2011, where Barbara Bagley was driving the vehicle in the Nevada desert at the time when she hit a sagebrush and flipped the Range Rover over. Her husband was thrown from the car and later died from his injuries. Bagley acted in two capacities: as the personal representative and heir of her husband's estate, plaintiff, and as the driver responsible for the accident, defendant. She loved her husband a lot, it seems. Yep, people love in this world. Only a few don't. And that's why we had these ghost stories in our list. Keep loving. Let's see what Miss Bagley's case has to offer. She filed the lawsuit against herself under Utah's wrongful death and survival statutes to claim damages from her insurance company, which had refused to pay. The case was initially dismissed by a district court, which ruled that a person cannot sue themselves. However, the Utah Court of Appeals reinstated the suit, interpreting that state law did not explicitly bar such a claim. That is the power of a wife, maybe. It's rightly said that when a woman loves, she can go to any extent. Bagley's attorney said she is advancing this lawsuit for the benefit of her husband's estate because creditors will have to be paid before the widow can receive any money as her husband's only heir. But how should the jury come to any conclusion? John Holcomb, professor in the Department of Business Ethics and Legal Studies at the University of Denver's Daniels College of Business, told CBS's Money Watch the lawsuit is quirky and also clever. The insurance company represented her interests as the defendant. This case raised ethical and legal questions about allowing a person to receive compensation for their own negligence. Nevertheless, the Utah Supreme Court affirmed the appellate court ruling, allowing Bagley to continue pursuing damages from her insurer for the injuries and death caused by her driving. Bagley, as the two plaintiffs, is really trying to get Bagley's insurance carrier to pay for Bagley's negligence, Holcomb said. Obviously, if she would have won the case, it would have set a very wrong example, maybe. In future, people would end up doing the same with the intention of looting the government. So, that was the video, guys. Apart from the result, I personally would salute the plaintiffs for showing such courage. I'd love to talk the entire day, but good things do come to an end. Let me know in the comments section what you would have done if you were in place of Barbara. I trust you guys have already subscribed to the channel and also pressed the bell icon. But it's a good deed to let other people know that you watch top-notch content and get knowledge too. Until next time, I'll bring some more crazy things happening around the world before you. See you guys.